Okay, so access to records. Parents must have the opportunity to inspect and review all educational records related to their child's identification, evaluation, and educational placement, and the provision of FAPE for the child. Access to records must be made available within 45 days of request. So anytime we're dealing with a timeline, you always want to make sure that that request is in writing. And districts are not required to provide copies of those educational records, but they are required to provide access for the parent to review. If you need access to those records to prepare for a school meeting in order to advocate for your child, the district needs to expedite that request so that you have plenty of time to gather the information that you need in order to fully participate in that meeting. Okay, so taking a closer look at parent participation, parents have the right to participate in meetings related to the identification, evaluation, and educational placement of the child and provision of FAPE for the child, including IEP meetings. Parents are members of the group that determines whether or not the child is a child with a disability, and also determining programming needs for their child through that IEP team meeting. In order to ensure that parents participate in all of those aspects of their child's programming, the district needs to provide the parent with appropriate notice of meeting. And they also need to use other methods to ensure parent participation in IEP meetings and placement meetings. So all meetings need to be held on a mutually agreeable date, and that can be very difficult to get all of those team members at the same place at the same time. Understanding that they can use other means of participation, either for the parents or other team members, is important. So you can have team members participate via conference call or video conferencing, and that might be one way to make it easier to schedule those team meetings. The district also has to provide notification of meeting to the parents at least 10 days prior to the meeting date. This gives the parent time to prepare and plan for the meeting. The meeting notification can be very important. It includes the purpose, time, and location of the meeting, and who is attending the meeting. It also explains the parent's right to invite individuals with knowledge or special expertise about the child. So when you get that meeting notification, make sure that you look at the purpose of the meeting. It may say to review or revise the IEP. It may say to review the results of an evaluation and to review or revise the IEP. Knowing what's going to happen at the meeting helps the parent prepare for that meeting. Also, looking at who's going to be attending the meeting will give the parents an idea of what is going to be discussed. And as stated, the parents have the right to invite any individual with knowledge or special expertise about the child. So, and that's also listed in your parent's Bill of Rights. So the parent gets to determine who has knowledge or special expertise about your child, and those people can be invited to the meeting and be full participants in the meeting. So that can be an advocate, it could be a private therapist, it could be a caregiver, it could be your mom, you know, and we always suggest including somebody else in those meetings to be a second set of ears. It's a lot of information to go over. Your procedural safeguards also go over complaint procedures. So we try to resolve complaints in the IEP meeting or resolve differences in the IEP meeting. That's your first level of working out those differences. The state offers free mediation, the Department of Elementary and Secondary Education, and you can request voluntary mediation. So a parent can request voluntary mediation, and so can the district. But it is voluntary, and just because a parent requests it does not mean that the district must agree to it. If they do agree to it, though, it is provided free of charge by Department of Elementary and Secondary Education. Any results of that mediation process are enforceable in court. So a mediation agreement is written and enforceable. Another step for complaint procedures is a due process hearing, and that is in regards to FAPE, free appropriate public education. So if a parent feels that the district is not providing that, then they can request a due process hearing. And that's kind of like a court proceeding. There's a hearing officer that listens to both sides, knows the law, and determines who's right. Before it gets to that due process hearing, once a parent files due process, the IDEA requires that a resolution meeting be held. And that resolution meeting has to be held unless the district and the parents agree not to hold that resolution meeting. It's basically a last attempt to resolve those differences and work out an agreement. And in a resolution meeting, if you work out agreement, that is also enforceable. And then there's a state child complaint process. And that is investigated by the Department of Elementary and Secondary Education, and that's usually for procedural errors. Your procedural safeguards also covers discipline procedures for students with disabilities. And they come into play when a student with a disability violates a school code of conduct and is subject to a disciplinary action. This is a pretty important process, so if you find yourself in this process, you may want to contact an advocate for support. But your procedural safeguards do go over your rights. It covers the authority of the school personnel. It talks about a manifestation determination. So if a student is suspended for more than 10 days, this team has to meet to determine whether or not the violation of the code of conduct is a manifestation of the disability, or is it related to the disability? And if so, certain procedures need to be followed. If not, another set of procedures needs to be followed. So that's why it's a very important process. It talks about the services that must be provided in this situation, any interim alternative educational settings that the child might be placed in during this process, what your appeal options are, the child's placement during those appeal processes, protections for children who are not yet determined eligible under special education and related services, and then exactly what constitutes a change of placement because of a disciplinary removal. So those are the highlights of the procedural safeguards. There's a lot more information in those, but those are the ones that parents use most often.